So we start with the panel devoted to the analysis of virtual worlds as market. I have to say that this is a topic that comes very close to my heart because I have been working since my doctoral thesis on platforms, digital platforms, and indeed my first work was related to the fact of platforms conceived as market. So this is in a way the next step in the evolution of the digital economy, to which extent this kind of world, immersive, sensorial, experiential, could work as well as market. And that is the reason why in this excellence panel that I'm so pleased to chair, we have four very good and very insightful papers. They are going to address the kind of issue, legal issue, that could arise when we approach virtual worlds from the perspective of market. We are going to consider to which extent in this market we do have assets, to which extent these assets are going to be transferred, negotiated, transacted, and that is the reason why we will have the first paper devoted to that. Because we have market, we are going to have marketing strategies, we are going to have consumer who might need certain protection, and we are going to have as well unfair commercial practices. And this is the reason why we have gathered this excellent paper under the panel on virtual worlds as market. So what I'm going to do is I'm going to give the floor to each of the panelists. They're going to present their papers about 7 to 10 minutes. And immediately afterwards, I will call, please, the discussant for the purpose of opening the discussion on the papers, and then come back again to the panelists and address the question that has been raised. So the first panelist, the first paper we are going to discuss, Ana Mercedes López Rodríguez. She is Associate Professor of International Private Law at the Loyola University in Sevilla.
Thank you very much, Ana. Yeah, I'm going to stand up, because I am kind of an active person, and I don't like sitting down. So, so the title of my presentation is Location, 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 Law Applicable to Virtual Real Estate. And, I'll try to be brief, but I'll have an introduction. I will try to sort of present the legal framework and categorize virtual real estate. Then I'll touch upon some choice of law issues, come up with some suggestions, and finally I will conclude. So, when you think of investing in real estate in the real world, what do you think of? If you're going to put your money in some real estate, what do you think of? Price, you think of location, size, and also if you're going to invest a lot of money, you also think about having a robust legal framework, right? So if you are expropriated, then you are compensated properly. Well, the same in the metaverse, or at least that's what we should look for in the metaverse. And both entities and businesses are increasingly being present and investing in the metaverse, so that virtual real estate is gaining increasingly importance in this rush to be present in the metaverse. Platforms like crypto, like voxels, the Sandbox, the Decentraland, and they show this rush to be present in the metaverse. But are those investments safe? So, first of all, we need to define what we are talking about when we are speaking of virtual real estate. Basically, or in general terms, these are buildings and lands that users can buy, purchase, resell, rent for different purposes. Can be from leisure, entertainment, commercial activities. And the thing is that the property systems in the metaverse, they mirror the property systems in real life. And at least in the West, it is so that we haven't figured out how to organize interpersonal relations when resources are scarce. So we have property systems. And people do consider those things as property, as genuine property. It's not a game. So how do we protect that property? We can categorize, as I mentioned in the introduction, virtual real estate in different ways. Our first characterization could be virtual land as real estate, like in the real world. And well, the metaverse tries to mirror the physical world, at least at the very moment. Maybe in the future it will be the physical world that will try to mirror the metaverse. But right now we are trying to mirror the real world. So, well, when you buy a building, when you buy a plot of land, factors like proximity to a popular spot, like adjacency to infrastructure, these are significant factors in the value of a property, like in the real world. The fact that there's no portability, that those buildings, those plots of land, they intend to be in the very same place. So those are factors that point in the direction of considering virtual land as real estate, as immovable property. As an anecdote, there are tribes, indigenous tribes, that claim land in the metaverse, so trying to avoid past injustices. So people feel that this is real estate. The problem is that, what about if those buildings or plots of land are expropriated? We don't have any constitutional protected rights against expropriation. So this is something that, well, puts, some doubt as to categorizing virtual land as real estate. Then we could also categorize, and this is the most common or accepted characterization of virtual land as crypto assets, as intangible property, intangible movable property. They are not rooted in any country as the typical definitions of real estate. And these are intangible property whose ownership is backed by NFTs, non-fungible tokens. But again, I have my doubts as to categorizing virtual land as crypto assets, because the intrinsic value of the property, or the property of the value of the property, is not its intrinsic value, but it depends very much on location as real estate. So this is not crypto assets. I know this is the majority view. Even platforms like the Central Land, they categorize lands and buildings as crypto assets, but I have my doubts. I mean, just because they say it doesn't mean it is. Or it has to be. And there's the possibility as well of characterizing these lands and buildings as licensing agreements, because the fact that you have an NFT that can be programmed to have the developer keeping track and even obtaining some of the profits of the subsequent purchases, this doesn't fit well with property rights. Because when you sell a property and you transfer it and you have fully paid for it, the previous seller doesn't keep any rights on the property, right? So, but again, it depends on how those arrangements are programmed and the degree of control that the developer has over the building or land. So this is the characterization or possible characterizations of virtual land, which I don't think that any of them fits really with virtual real estate. And then we have the choice of law issues, because most, the metaverse is essentially cross-border. It's delocalized, so there will always be questions on which law applies of the possible that are connected to the case. And here I'm not going to go into details. I do discuss it in my paper with more detail, but I won't bother you, especially if you're not private international law specialists. But basically is that no matter how you characterize real estate, virtual real estate, property issues normally are governed by the law of the place where the immovable is situated. The lex res site. That's why location in my paper. I know that if it's characterized as crypto assets, they're trying to overcome the problems with locating the crypto asset in different ways. recent legislations in Germany, also the principles, the European Law Institute principles on digital assets as securities, the UNIDROIT principles on digital assets, they try to use different connecting points, like the issuer, the supervising authority, even the Lex Fori, but this is complicated in a decentralized environment. Then the contractual issues like transactions, you sell a building, you rent a building. Those are contractual issues and normally choice of law rules, not only in Europe but other places, they choose connecting points such as the habitual residence of the seller, for example, or the service provider. In this case, it's not any service provider, it is a license agreement. Then the developer, and the problem is that sometimes you don't even know who that person is or what's the habitual residence, because the metaverse is delocalized and many operate under a pseudonymous, or they are difficult to localize. So, and the closest connection is also very difficult to establish in a decentralized environment. So anyway, there are challenges on placing what private international law usually does is try to localize a legal relationship in a legal system. This in the metaverse poses many challenges, the same way as jurisdictional issues. And that's why there are some platforms, some of them DAOs, that are offering services in the metaverse, conflict resolution services. The problem is, I've spoken about this elsewhere, the problem is that they use game theory and economic incentives. And when we are dealing with property issues, there's a public law component and issues of publicity, how to register and so on. Well, these guys are not taking it into account. So here, unlike contractual law, it's very important to check the legality of the operations and that the rights of consumers are taken into account as well. And, well, I haven't figured out how to cope with those issues, but I do conclude in my paper that I think that initiatives like the European Law Institute and UNIDROIT on digital assets, on smart contracts, could be a source of inspiration for those organizations to develop rules on virtual real estate that could function as models for arbitrators. And, you know, in due time, maybe they become the substantive law of the metaverse. You don't even need to have choice of law rules, because in arbitration, there's something called Y-direct, where you can just choose the rules, substantive rules you deem appropriate. You can do that. But again, especially in the context of the metaverse, some of these decisions will be self-executing. There will be no tribunals controlling the legality of those decisions. So it's very important that the substantive rules that are applied, that they respect, as I mentioned, the rights of consumers, that they respect competition, that they take into account the erga omnes and all the publicity that are required regarding immovable property. So just to conclude, I think that we need a regulatory framework that transcends geographical boundaries like we have in the real world. I think we should protect investments and investments in real estate, virtual real estate, by characterizing virtual lands as immovable property or something close to it. And especially the issue of expropriation, it's quite significant. I mean, we should regulate this, especially if you're investing a lot of money in a property. And again, initiatives like I'm just concluding, like these organizations, I think it's a good starting point. They did it with the UNIDROIT principles on commercial contracts. They have been applied in arbitration, the source of lex mercatoria even. So I think this is a path to follow. And what I think is that we have all, even legal scholars, the responsibility of like developing rules and principles that, that support a responsible metaverse that takes into account the rights and interests of all the parties involved. So thank you.
Thank you very much, Anna. Indeed, I agree with you that it's much more convincing to approach this virtual land as a virtual real asset or immovable asset more than this kind of, let's say, circular analysis that in a way they are not encapsulating the real perception that the parties have when they are dealing with this kind of asset. So now we have another perspective. We are in a market, and therefore we are going to have certainly marketing strategies. And this is exactly the paper that Jacopo CIANI is going to present. He's a research fellow at the Universidad degli Studi di Torino, and he's also adjunct professor at the ESCP Europe in Torino as well. So please, Jacopo, your floor is yours.
Can I just have the device?
Sure. Yes, please.
Thank you very much, Teresa. Thank you very much, Aurelio, Manuel, for the amazing event or the organization, and for having my paper as well. For those of you that were lucky enough to attend the keynote speech by Nuria yesterday, she presented phenomenon of wide use of beauty filter, a beautyverse that basically creates a lot of fictional character populating our virtual environment and in particular the metaverse. And my presentation builds exactly on this scenario. Of course, my interest is more focused on the legal framework for fighting the risk of biases, the risk of deception, and unfair commercial practices that may arise when people, users, consumers are not able to understand that this kind of virtual influencers are actually not real persons. I will start from a provoking slides. Can you recognize who is the computer-generated influencer here? Of course, is a rhetoric question. I think it is quite difficult for everyone. The fake one is the middle one, but I think it is really pretty the same of the other two figures. So we have actually a situation where it is quite difficult to understand what is real, what is fake. My paper builds on 5 pillars. The first one is a description, an attempt to describe the increasing use of virtual influencer, conversational agents in digital environments. Actually, the metaverse is more an excuse than other because, of course, this phenomenon does not concern only the metaverse but all the digital environments. And is a phenomenon that is increasing. Some statistics says that it shall increase in the next few years in a quite pervasive way. I use a very general concept of conversational agents, of virtual influencer. It is not really important for me how many followers they have, if they are avatar of celebrities, or if they are totally fictional characters. There are 2 elements that are quite important to me. The first one is that we may have a very strong level of similarity with a human appearance. We call them hyper-realistic characters. And the second point is that they may be created with very different technologies. Normally experts distinguish in a quite simplistic way between computer-generated influencer and AI-generated ones. The technology, of course, generate very different capabilities among these kind of virtual characters. Just to mention, AI-driven, the imaging refers to Baby X. It is an 18-month baby developed by a New Zealand company, Soul Machines, as human-like abilities and emotion driven by a brain modeling component that basically is able to connect events, to store them, and to develop emotion in correspondence with the interaction with human beings that stay in front of the device. While this is not possible, of course, for just a computer-generated ones. But at the end of the day, the external aspect may be very similar, and your ability to distinguish a computer-generated or an AI-generated one may be very difficult. Here we have the imaging of astronauts generated or by AI or by computer. Why is important this distinction to me? Because actually the legal framework address only AI-generated conversational agents, thanks to the newly adopted AI Act. In particular, I refer to the provision of Article 50 that introduced a two-tier system for a duty of disclosure of the AI-generated nature or manipulated nature of these conversational agents. A two-tier system because the duty of transparency concerns both the providers of the AI system or the deployers, so who use it. In the paper, I analyzed this legal framework with some critics, for example, due to the exception that allow providers not to mark or label the AI nature of these fictional characters. There is an exception when the AI nature is obvious. Of course, obviousness is a subjective criteria, but more than this, I think that the general regulation on unfair commercial practice, and in particular the duty of disclosure of hidden advertising, does not allow not to disclose the advertising nature when it is obvious from the context. It is not enough that the post is branded by Nike for avoiding any disclosure of the advertising nature. So it is quite strange for me, this exception. Also, we have another exception for deployers concerning in particular the possibility to make a more comfortable disclosure of the AI nature when the content has an artistic nature. I think that a copyright lawyer would say that a virtual influencer may be a work of art protected by copyright, so probably this exception could be applied, but in a commercial purpose, like the one we face in advertising. We do not we don't have a rationale for allowing a complete enjoyment of the artistic content, so probably this exception is not so useful. Apart from the AI Act, we have some national legislative intervention. I just mentioned India for extra-Europe countries. The US provides something with the new release of the FTC endorsement guides, but does not introduce a real duty of disclosing virtual identity. And then we have France, that is probably the more advanced country in Europe on these topics. In Italy, we are working on a proposal for an AI bill, and in this scenario, we have platforms that are proposing various instances, and I would say that everyone makes what it considers more appropriated with, for example, Meta is trying to introduce an AI detection software. Instead, TikTok and YouTube just ask the user to mark or label the content. So we need harmonization. We have a general legislation that provides some general law that may be extensively interpreted and applied in order to state the need of a disclosure of the AI-generated nature, but probably we need some kind of intervention that cover also computer-generated virtual character, not only AI manipulated ones. These are my conclusions. Thank you very much.
Thank you, Jacopo. No, indeed, transparency obligation is not neither a unified nor a homogeneous category. And as you can see, and you have proved very convincingly in your paper, there are disclosure duties that are for different purposes. In a way, this idea of excluding certain situation where it's obvious or unnecessary to disclose, we also propose that in the ELI ADM, the ELI principle on ADM, believing that if this is a robot, for example, it's so obvious that I'm interacting with an AI system. So maybe makes sense in the context of the AI system regulation. Definitely is not for the purpose of, as you said, unfair commercial practices or marketing. So excellent paper, thank you very much. Now we have the third paper that is going to dive into this idea that virtual worlds could be marketed from the perspective of property rights, NFTs, and licensing agreement. So we have Marcos CRUZ González. He's a substitute professor of commercial law in University of Salamanca. And you have the floor, Marcos.
Okay, thank you.
Thank you.
May I have the slide changer? Yes. Okay. Thank you, everyone, for your attention. Thank you for attending this, not last, but this virtual worlds as market table, which is a little bit technical, a little bit hard to follow. I'm going to do. There's going to be like some dichotomy in my exposition, because I am going to work to make the presentation as a work in progress, like how I went to the conclusions I went, but I'm going to present more nuanced, finalized bullet point conclusions in each time. So it's going, or maybe it provides not exactly the idea you may be thinking. Okay, so pretty much what we have here is a loading screen. That's what actually the metaverse is currently right now. It's loading. We're still, and we have seen it these days, we're still loading the world, we're still creating the world. That means we're creating the infrastructure it's going to be built upon, which means that we are at the sweet point for us to think what we are going to address, how we're going to address, right? What we haven't delved these days into the concept of the metaverse. I'm not going to do that either, but I take it as a starting point, because I think it's interesting that the main issue here is that we're still at uncertainty what the metaverse is going to be like. So this means there is some different conceptions. I found like each author that has delved into it has its own different ideas. And I think that makes the metaverse some kinds of a buzzword. We use it a lot, we don't define it very much, so it's complex. We come from different backgrounds, we expect different things. I want to just make sure that I am also biased by this idea, okay? So the main thing we have here is that the metaverse, as a consensus to start, is going to be replicating the reality. That's the aim we are going for in order to fuse them finally, right? So what we need to address at some point is that the metaverse is going to work, or it's going to need to work as a market, right? Here we have these two-fold trend, these two phenomena, however you want to call it. That the one side we have some people, some scholars arguing for pushing towards segmentation and then centralization of the virtual worlds. This means we're going to have different virtual realms. In each virtual realm, we're going to have one platform operator. I'll take that later on, but we need to take into account this. So what we are pretty much going on is to take platform economy and going from a 2.0 perspective to a 3.0 perspective on the internet, right? Then we have the other side of the coin. Then we have this paradigm of Web 3.0, free creators economy, freedom of expression, peer-to-peer intercommunication and transactions. So we're going forward a unified metaverse with decentralized governance, or with decentralized operating, right? And this can be provoked, this can be caused, or can be influenced by some tools that I'm going to analyze here. I think intellectual property has an interesting role in this regard, because it can work as a virtual world infrastructure, and I'm going to try to explain a little bit what this means, right? Intellectual property is going to provide, in this market context, a digital infrastructure pretty much as it has already provided in the video games industry. Like ownership in video games, we have seen it earlier, it's pretty much conditioned by copyright law, and particularly by end user licenses, which may or may not be very appropriate for consumers at this point. The thing is that what we are having in the metaverse is like an expansion, a hyper expansion of copyright as it is right now regulated, especially if we take into account the low thresholds the Court of Justice of the European Union has established towards this concept of copyright protection. No? It's eligible for copyright anything that expresses the creative personality of the author, let's say like that, because there is a lot of people that is not experts on IP, on copyright specifically, but what we have here is anything that is not copied, strictly said, may be liable, may be likely for protection under copyright law. This means that all 3D models, or most 3D models, may be selectable, may enter in the copyright protection, which I think it could be rather dangerous. I'm going to explain a little bit more. The thing is that the IP has traditionally gone on a different plane here in our real world, in the physical world, has gone on a different level completely than physical property. That means that I have a book, I own the book, but I cannot exploit commercially that book because IP rights go on a different plane and I need the license in order to do so. The problem with digital worlds is that they are intertwined. We haven't really separated ownership from IP rights because it has always operated on these end user licensing agreements, right? So what I found is that if we are to create a frictionless and swift commercial flow that is key for having a virtual market that works as a real market, that is the final aim, the final goal of the metaverse in this point, what we are going to have is maybe some problems from the copyright side. What we find is that maybe copyright is not the best regime to take into account, though it's the one which is better positioned in this regard, and specifically it may trump a little bit this kind of one unified, quick, swift market, because let's take into account and take this with a grain of salt, because it's prepared for more unexplanatory than a technical standpoint, but what we have here would be the typical license flow from any kind of copyrighted work here on our physical world, right? So we have the creators, then the license to the producer, then producer or editor would license to a distributor generally, and then we fragment it on a territorial basis. The thing, then we have different channels, like for instance emitters, for instance broadcasters, and finally we have the user. This graph is only to explain that what we have here is a unidirectional downwards flow of licensing. This means it's fairly easy to track them back because we don't need to take like, here are like 4 licensing contracts, one in cascading with one another. Here was what I imagine, I think it would look like the flow of licenses in the metaverse. So we have no centralization. Creators can go directly into the market. They can sell in the marketplace. They can sell in a specialized marketplace because in NFT we have already seen that. And we have also the platform market. So we have different platforms, different markets, one orchestrator that may or may not be a digital platform of our traditional knowledge of what a digital platform may be. So the issue is here, what can a user do? And in order to ascertain what a user can do, we need to trace back the licenses all the way around the net, which may be kind of burdensome, which may be kind of a problematic approach. So this is what we have here. What can we do? Well, they came NFTs, they appeared yesterday, they have appeared today again. The NFTs came as the main solution, the main tool in order to what? Let's take this with attention. In order to facilitate digital ownership. Yeah? Mm-hmm. Not exactly to manage intellectual property rights relating to that digital asset I own. However, we have found some problems with NFTs. The first one is that we are not in agreement what the legal content of an NFT may be. Do they give ownership? Do they give property? Do they give anything at all? That's been a debate that is ongoing up to this day. We have some resolutions, some judicial decisions that have already appeared that suggested ownership, some kind of ownership in this regard, but it's still in flux, it's still being developed, like very much everything else. Then we still have the problem. NFTs will then operate on a different level. We have the ownership of the digital asset that may or may not be allowed by the NFT in itself, And then we have the intellectual property we are not to renounce because it is still valid, it is still functioning. So they operate on different dimensions. Corpus mechanicum versus corpus mysticum, same dichotomy we have here in the real world. It's allowed, what I think is the main point of NFTs, is that they allow this separation that on digital assets was not directly direct, right? It was harder to see, it was harder to feel like that. Then we still need IP license agreements. So we need to settle down how we're going to go from this mess, because it's kind of messy right now, so how we are going to order this to make it functional so that consumers know what they are buying and how to use them properly. And I took resource to some licensing system that is already existing, that is Creative Commons. I want to make here an important explanation. I'm not meaning that we need to take back to, or to go to a Creative Commons environment per se, but to take into account what Creative Commons as a structure has in licensing markets, right? And we have that Creative Commons licenses are made up of different modules of different rights that may or may not be, but they are maybe standardizable. It means that I can create general packed licenses where authors, creators, can opt in and opt out in a different way. So I have this standardized license that may be customizable, allowing us easy and easy, or some security, some securement in regarding what the users, what the consumers may be or may not be expecting, they know. And then we have what the authors can or cannot do with this system, right? So I think this modular structure of Creative Commons licenses is really interesting. Then we have the next level. They are indexed and maybe introduced in digital assets through metadata. So we can, these licenses can go everywhere the digital asset goes, making them rather suitable for this regard. And finally, they ideally, and they should be, because Creative Commons goes into this sense, they should be machine readable, meaning that we can automatize, we can make the assets compliance by design, so it's immersive. Consumers feel and really represent themselves what they can or they cannot do with these kinds of assets, because it's determined by this digital kind of code, this metadata. So if I am to expand the digital asset and the author does not allow it, I can't expand it. It has to be with a set dimension, with a set characteristics. So I think this modular licensing system may be a useful idea, maybe a useful starting point in order to regulate, to recreate this kind of licensing agreements. There are some examples, I will not delve into them. All of them are CCO licenses on the NFT side of the elements of this reality. I think it's interesting that NFTs are going in this direction with CCO licenses, relying on technology to control use. And I think we should go definitely into this direction if we are to create a decentralized metaverse that is not governed, is not structured by and for the platforms. Thank you very much.
Thank you. Thank you, Marcos. Very insightful analysis. I was wondering whether the fact that the legal content of the NFTs is uncertain is not indeed a problem. It's probably just inherent to the NFTs. They could be as diverse as we want to.
Yeah,
so maybe we could consider, we could discuss that later, no? To which extent it's a problem or it's just a diversity, and therefore we can use it for the different purposes that we want to. So excellent, thank you very much, it was really good. Now we have another perspective in the market, that is the role of consumer and how we protect the right of consumer in the metaverse. For that paper, that is going to be the last one, we have Germán Darío FLÓREZ ACERO. He is the director of the Master in Digital Law and Legal Tech of the Universidad Sergio Arboleda in Colombia. So you need this one. Germán, the floor is yours. Thank you.
Thank you very much for the invitation to Aurelio, and I'm very honored to be here, and also to my co-panelists that you have been a really great job, and actually, but I'm gonna talk about the consumer rights in the metaverse from the South American perspective, because you explained already a very, very interesting European perspective. And my intention is to show you like how the Latin American and the European perspective like join in the explanation about the consumer rights in the metaverse, because the metaverse have a very direct relation with the Web 3.0. Like, because when we're talking about the metaverse, we're talking about like a new e-commerce perspective. Like, because in the past, like the digital assets are like growing and growing a lot, but when we see what is like the purpose of the main companies that are distributing like NFTs, avatars, or any digital property, like the houses in the metaverse and things like that, is because those companies are thinking about like in the future, are thinking about in the market, in the metaverse. Actually, when we see the studies like McKinsey, the metaverse is around 3% of the gross domestic products in some countries of China. In China is actually the 7.1% of the GDP. What means all the potential that this kind of market have in the global economy. That's why it's super important to analyze how can we regulate the rights of the consumers. What would be, because many of you already mentioned about the global dimension of the metaverse and how like the jurisdiction could be a very problematical issue, legal issue, when we're having problems. Actually, at the end of my presentation, I will put some problems that already we have. So the value creation in the metaverse is like enormous. Every time we have like more and more things like relating to metaverse. I don't know if you see, for example, like in the last couple of months, like WhatsApp created like a new platform that is selling avatars, but it's not selling, it's providing avatars for all the consumers of the metaverse. But when you create your avatar, you see a list of things that you can buy for the avatar, like sport shoes, like sweaters, like clothes for the avatar, and they are like charging you like real money, depending of the trademark, depending of the things that you are using for this avatar. And this is just a small part of what is gonna be in the metaverse in the near future, because at the beginning, and I remember like 14 years ago when Gaetano was like telling me about that in Queen Mary University about the Second Life things, and I remember my classmates, they were saying Gaetano is a little bit crazy talking about this, but I was thinking that's not really true. And nowadays we are seeing this enormous digital market. Actually, the Gardner Foundation in 2022 made like a study about the elements of the metaverse, and we can see a lot of the elements that we have been discussing in this table, like the workplace, the online shopping, social media, digital humans, digital assets, and they are like the main challenges that we have now in the metaverse. And for this perspective, I will analyze now a little bit like the natural goods in the metaverse. So we have, as I explained before, like the virtual goods that are digital objects that can be bought, rented, distributed in the metaverse, like the NFTs, like the properties, and this is the virtual goods are like probably like we have now NFT, digital goods, cryptocurrency, virtual real estates, and they're probably like the most trending things that is necessary to regulate. As my colleague mentions, like every of these digital assets have a different nature. Probably we need specific rules for all these things, because one thing is an NFT and another thing is a real estate. So, but all of them are digital assets after the end of the day. For example, NFTs is a very complex thing because NFTs have a direct relation with the intellectual property rights. I saw like a case in Barcelona, like recently, about the case of Miro with Mango, and how the tribunal analyzed if it was like infringing of the copyright law for using NFTs in the metaverse. Very, very interesting. These cases are already happening. We have also personalized experiences. This is very interesting for the consumer law because consumer law is also about services, like in the entertainment way, like concerts, like video games, like these kind of things. And in the metaverse, we have the advantage that, for example, let's think about a concert. In a normal concert, like 50, 60,000 people can attend a concert. But in the metaverse, we have like millions of people. This is an example of the concept of J Balvin with Meta and iHeartRadio. He made the concert like almost 2 years ago, and more than 200,000 people attended the concert of reggaeton of J Balvin. And it's interesting for the point of view that more people can attend this kind of spectacular, this kind of shows, but also for the consumer law is a big challenge because it's a potential of 200,000 claims if something is going wrong. And this is a very, very special or very particular issue for judges because normally consumer law judges, they have like a lot of case law. For example, in Colombia, that is my jurisdiction, like 3 years ago, the consumer judges, they were like very effective. They solved problems or issues for consumers like in an average of 7 months. That's a very good period for South American justice. But nowadays, it's like almost 2 years, the period when the judge is solving a problem. So can you imagine now if this judge should like solve claims such as this, like 1 million people claiming because the metaverse didn't work? Because it could happen, or it could happen that a hacker attack the concert or whatever. It's something that we have to think about it, because if we're creating a world in the metaverse, we need to create solutions for the metaverse. We cannot keep the solutions in the thinking in the real world. So I have more examples of the virtual markets like Nightland. Also, the universities is starting like Metaverse campus. This is an example of my university, Sergio Arboleda. We create like a campus in the Metaverse already. And this is like the rights that we have to take into account for the protection, like quality of the products, security, indemnity, right to receive information. This is super important for all consumers in the Metaverse. The right for protection against misleading advertising, right to claim, education rights, protection against abusive clauses. And it's very interesting because the regulation in Latin America, in most countries such as Argentina, Colombia, Costa Rica, Chile, are very similar to the European Consumer Act and the E-Commerce Act. We're talking the same language, and that's really important for a global regulation. So one of the things that could help with these things, just to finish my presentation, is to think about a metaverse jurisdiction. That's not really crazy. And actually, there is one example of a judge in Colombia, in Santa Marta. The tribunal, the administrative tribunal in 2022 made the first hearing in the metaverse in Latin America, and one of the first in the world. Everything was in the metaverse, and it was a lot of criticism, but the World Economic Forum made a blog saying that it was very interesting to create these kind of things, because if you have like a metaverse, the most logical thing is that you have judges in the Metaverse. So thank you very much.
Thank you very much, Germán. Very interesting. Indeed, probably one main question that we may discuss later is to which extent the consumer in the metaverse is a more or less vulnerable consumer. So to which extent we need not only to apply the same protection right, but maybe to enhance the protection of the consumer. Or on the contrary, we do not have such a level of vulnerability and we can even reduce the level of protection in the metaverse. So just to open a further debate. In the meantime, I would like to give the floor to one of our discussants, Antonio Serrano Citores. He's Associate Professor of Commercial Law in Universidad Rey Juan Carlos of Madrid. So please, Antonio, between 10 and 15 minutes, if that is okay.
Yeah, that's perfect.
That's perfect. Thank you so much.
Well, thank you so much. I'm really happy to be here today. First of all, because I've been invited to a city that I love. I believe that I'm going to retire here, so thank you very much, Aurelio. Thank you very much. Manuel, as I told you, I would like you to adopt me in this university, so I'm really happy. I'm really happy as well because the papers that we are discussing were of great quality, of outstanding quality, so congratulations to all the authors. And as well, really happy because I truly admire Professor Rodríguez de las Heras. Many of my papers and many of my studies have their origin in many of the papers she wrote. So being here with you, it's a real honor. And of course, having the honor of being with Giovanni as well, it's a real pleasure. My approach is going to be divided into two parts. The first one would be food for thought, general reflections. And the second one will try to dive into different papers and general analysis and maybe some suggestions that, of course, you can listen to them or not, okay? So starting for all these general reflections, I would say that, well, Mario Benedetti used to say that when we had all the answers, they changed all the questions. And that's probably what we're seeing now with Metaverse, with artificial intelligence, with all these disruptive technologies. Because this panel is called Virtual Worlds as Markets. And the world, physical or virtual, has many questions. And all of us here, we can be the answer through education, through what we are doing. And this is something that I believe that we have to congratulate all here for being here. But I will try to analyze the world and I will try to analyze the markets because I believe that these terms have changed. They have really changed and they are changing because everything, it's changing. And I'm speaking quite a lot about change. I would say as well that education does not change the world, but it changes people who change the world. Again, change, you see. We have to understand that these markets, when we studied them in commercial law at university, we usually define them as the physical or virtual locations where we were exchanging goods and services, where supply and demand were meeting and pricing appeared. But now it's not just products and services, it's experiences, and I will go onto that later. So the markets are changing, the economy is changing. Why? Because we are in an era of changes or a change of era. We are transitioning. We are suffering three transitions at the same time. A transition of power between China and the United States. We're in a two-sided trap, fight for power with hybrid wars. We're in a transition of energy. And we are in a transition from an analog economy to a digital economy, maybe to a metaverse economy. And this changes the paradigms, we know. Why? Because these three transitions are happening at the same time and they are related. And these transitions, and the last one mainly, which is the one that we are focusing here, we have to understand that changing from analog to digital means changing from scarcity to abundance, which is something that you mentioned before. And this changes quite a lot because economy is defined as the science of election, as the science of, well, managing scarcity. What happens if this is no longer true? So in my opinion, this economy needs to, well, contain additional adjectives or prepositional groups such as a data economy, exponential economy. The metaverse is an aggregator of disruptive technologies as such. We are speaking of a token economy. We are speaking of an attention economy. All the platforms in the metaverse, they try to attract our attention, our time, probably our most precious treasure as such, our time. We are speaking of an automated economy. We are speaking, and I will be dealing with that later, of an experience economy, of a platform economy, and of course of an uncertainty economy. Uncertainty, which is quite common. I mean, Heraclitus from Ephesus always said that everything changes, everything flows, you don't bathe twice in the same river because you are not the same person when you go again to the river and the river is not the same. So against uncertainty, and here I will be ending my general thoughts, against uncertainty, what can we do? How can we deal with uncertainty? I would say 2 tips. The first one is legal certainty. Legal practitioners. Regulations, who knows? I will provoke with this a bit later. And the second thing is education. So against uncertainty, legal certainty, and education. But going to the specific papers, and after reading all of them, which I believe they are of the utmost interest, I have tried to sum up into 4 topics that I've been seeing. The first one would be the Lex Metaversi, that I really liked it, because I remember when I started teaching commercial law in English, that I used the first handbook in English of private law, which was written by Professor Rodriguez de las Heras, and she was saying, well, she was explaining what was happening with the Lex Mercatoria. The Lex Mercatoria was an international, was really great during the Middle Ages, but when the states appeared in the modern ages, it broke completely the uniformity. The metaverse is a multiverse of metaverse, is a multiverse of platforms, and the platforms, at the end of the day, are virtual states. If you remember when we studied constitutional law, the 3 key elements of a state were territory, population, and sovereignty, together with some additional elements that could be or not, such as language or coin. Well, any of these platforms have territory, population, and sovereignty. The terms and conditions could be the digital constitution. So if we are speaking of a Lex Metaversi, what happens if we have many platforms? Is it going to keep its uniformity? This is something that maybe you could address in your papers. The second idea, and I have tried to group, is about risks. I mean, we are legal practitioners, so we deal with risks. And this is something that, as well, I learned from Professor Rodriguez de las Heras. Do new facts need new regulations? Because usually law is reactive, not proactive. But in my opinion, even if we are seeing how in Europe many rules, many regulations are being passed and approved, I believe that the Constitution, the other rules that we already have, the existing rules, have enough mechanisms to fill these loopholes with general principles of law, customs, analogy, and in the common law systems through the judge's creation of law. But this said, I believe that, of course, we have to update rules as well, but maybe not as many rules as we believe. This is something, again, for discussion. But when we analyze risks, I have seen that Metaverse mainly has 2 risks. One is privacy, and the second one is security, consumer security or transparency. And again, and this is a provoking question, we are focusing too much in transparency, for example, now with the AI, with the black box algorithms. And here's my question. When you drive a car, how many here open the car and see the engine or the elevator? Because we are using gatekeepers to full trust through certificates, through self-regulation. So maybe we shouldn't be so worried about these technologies and try to work in this sense. And the third one, I would say that we are seeing, and this has been seen in Marcos and Anna's paper, the other ones were in Jacopo's and Germán, we are seeing a switch from an age of ownership to an age of access. And this is quite related to the experience economy that I was saying before. Mainly, we have to bear in mind, and here I recommend you all, Joe Pine's The Experience Economy. He basically says the following. At the beginning, what we had were raw materials. Through technologies, we were able to customize those raw materials, let's think of grains of coffee, and transform it into a product, a package of coffee in a supermarket. We went even further, and through new technologies, we were able to transform the product into a service. We were able to have a cup of coffee in a bar, in a pub, okay? But we went even further, and with new technologies, we were able to customize the service and then transform it into experiences. And this is basically what the metaverse is about experiences. And the final step would be hyper-customizing through these new super technologies from this fourth industrial revolution and transforming these experiences into transformative experiences. And let's think about it. The best moments of our life are not property, are experiences. A kiss, a trip, professional success. All these things are taken into account by all these platforms. So this is a reflection, and to end with my reflections, I would say, and taking into account your final thoughts, we have to try to boost an Hispanic approach of all these technologies. I would focus on artificial intelligence, but as well on the metaverse. Of course, we have all South and Central America, but the United States has 70 million of Hispanic population. Altogether in the world, 600 million people. I believe that there is a need of an approach, of an analysis from the Hispanic community as such. I end with just 4 recommendations, again, so as to face uncertainty, which I usually call them the 4 E's, which are, the first one is effort, the second one is excellence, excellence or nothing, doing things better every day. The third one would be ethics, and the fourth one would be education. Education comes from Latin, which is educare, guiding, which is synonym with leadership, guiding as well. Thank you very much, and open to further discussion later. Thank you so much.
Antonio, thank you very much for your kind comment and all the inspiring insight. Very much appreciated. Indeed, I find very inspiring 2 ideas. The first one is to which extent, therefore, we have to talk about market of experiences in the metaverse instead of asset, product, and services, as you mentioned. And the second one is to which extent transparency is becoming an obsession and it's not indeed the right policy direction that we should take, because there are other mechanisms as gatekeepers you mentioned. Thank you very much, Antonio. And I have the pleasure to introduce Giovanni Maria Riccio. He's Professor of Commercial and Comparative Law at the Università di Salerno, and founder and senior partner of the law firm ILEX. So, Giovanni,
thank you so much. And I think that Antonio already said everything, so I will just limit my intervention in order to thank Aurelio and Manuel and also Giovanni Sorrentino who chose at me. And if there is another place for retirement, I am absolutely open to it. And I will be retired much earlier than Antonio, so I mean, take this, keep in mind. So, also, thanks a lot to all the speakers, as long as I've learned many things from your papers, and they were all excellent. I will be focused mostly on your papers than on general topics. And I'm sorry, because I'm getting older, so I need to enter into my personal metaverse with my glasses. And I did also appreciate the fact that metaverse is strictly related to imagination, and imagination is a human capability. Only humans, as far as I know, can imagine, and this is also the main difference between the Neanderthals and the Homo sapiens, and we are still Homo sapiens. So I do appreciate that we all have this capability, because I found a lot of imagination in your papers, and one of the things that I appreciated the most is the fact that you didn't express the need of a new law or a new something. Because I think that we have already on IT law a too crowded legal environment, so we have already too many rules. So I totally agree with you, and also your presentations were even better than the papers, in the sense that, there was something unclear, and I had some remarks, but unfortunately I have any remarks after your speech, but the first general point is that this is a suggestion, and Jan de Bruyn already mentioned this before lunch. I am a professor of comparative law, use comparative law, and comparative law is not a list of regulations from other states. It's a method, and you can also understand something of your own law, of your own national law through comparative approach. And I've noticed that all the papers had some references to other states' regulations. There is also another common aspect which has not been, Antonio spoke about everything, so, but there is something probably Antonio didn't mention, which was the transparency obligations. Did you mention transparency obligation? Maybe I was distracted. No, okay, thank you. So the transparency obligations, because in all these regulations, there is always a reference to transparency obligations in terms and conditions, also in licensing agreement, also in the German paper there was this reference. And I think that we should consider what really means this obligation, in the sense that transparency also in the Artificial Intelligence Act is something which is quite vague, and it's, it seems more something which is formal than substantive, in the sense that it's, are we really protecting consumers and users, or it's just a formal obligation to comply with. On the single papers, Anna, as for your papers, I found very interesting the reference to expropriation. There are some countries in which there is a constitutional protection of expropriation, but I think that it's a great point to work on. Also, I am not really convinced about, and unfortunately Antonio mentioned this, about the Lex Metaversi, in the sense that, as Antonio said, Lex Mercatoria also during the debate, the first debates on the internet law, there was also always this reference to Lex Mercatoria, and then all of a sudden it was abandoned because, you know, when you have huge economic interests, nobody's really taking care of a Lex Mercatoria or something which is related to soft law. On the other side, it should seem also schizophrenic, but I did appreciate a lot the reference to the UNIDROIT principles. I think that mostly on negotiations they could be very, very useful. I would consider something which is not related to private international law, I know, but which is about formalities in the acts, in the legal acts concerning immovable properties. There is an historical reason, because generally immovables mean the main patrimonial capability of a family. So there are these formalities for, at least in civil law, in all the countries, in Italy, in France, in Spain, in UK it's something different, but I mean, you have also some rules related to this. As for your paper, Jacopo, we have already discussed this yesterday, but the point is that probably we should pay attention to the fragmentation of the rules, in the sense that I do not agree with the French approach. Let's make our own regulation. It has no sense, to be honest, and also it jeopardizes probably the harmonization purpose on the one side, and also the unification of the rules, because we have this difference of legislative acts, because on the artificial intelligence, on, for example, digital platforms, we have regulations. On consumer law, we mainly have directives. So let's try to protect this harmonization and do not use national paths, like for example in France or also in Italy. There is also another aspect which is on which you should work on, in my view, because you had you made a great remark regarding artificial intelligence and the obvious from the point of view and blah 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 and the circumstances and whatsoever. And it is strange because I mean it is not explained the burden of proof if relies on the providers or on the other side. Marcos, I had a lot of remarks for you because I'm also expected to be as a copyright scholar, maybe Gaetano, well, can you confirm? And but I have to because the point was that in your paper, but probably I misunderstood. I'm sure that I misunderstood after your presentation. There was this reference to the, you call it modular licensing frameworks, okay? And it seems to me that it was too complicated as for transaction costs, but you perfectly explained that you mentioned a kind of list of potential licensing agreements. So that's perfect, so no remarks at all. And finally, German, Dario, FLÓREZ, ACERO. I really appreciated your paper. As I said yesterday, I mean, after a couple of spritz and a couple of beer, I say this, but I can confirm this in the afternoon, that you should work, because that will be extremely interesting for us, the Europeans. You should work on a comparative approach between the rules on consumer law in South America. You mentioned Argentina, Colombia, and other countries, I don't remember now, but, and on the other side, the rules on, of the European Union. And I think that is absolutely interesting also to understand the reasons of this imitation, if any, and also the difference that we have. Because you mentioned in your paper the consumer law of Colombia, Article 120, if I'm not wrong. But anyway, I'm not sure about the number of the article. But anyway, I think that you should follow this line, and you should follow this research. That will be, I don't know for you, but for us it will be absolutely useful, so keep going on this aspect. And finally, I mean, I'm Italian, I know, I cannot speak Spanish, but I can understand Spanish, so if you want to accept to the community of Spanish scholars, I will be absolutely happy to be here. Thank you very much.
Thank you, Giovanni. Indeed, this problem of fragmentation and proliferation of new regulation directive, in a way, provisions that are overlapping, that have different scope, that has been discussed, is indeed one of the, in my opinion, the biggest risk and the challenge that we have in the European Union for the regulation for the digital economy. So now we have time for questions. I would like to give the floor to the audience. If there is any question, please. Oh, sorry. No. Before they can address this comment, and then we open the floor, right? Sorry. So let's follow the same order. Okay. So Anna, please.
Yeah.
Sorry about that.
Yeah. So thank you very much for the discussants, and also for the organizers. I forgot to thank you in the beginning of my presentation for their very insightful comments. I really, you're giving me food for thought. Regarding the Lex Metaverse, because both of you have commented on it, Lex Metaverse virtual states, as I see it, this is a different phenomenon. Because the Lex Mercatoria, even Lex Cryptographia, there's many variants, right? They were mainly concerned with private law issues, but here we have a lot of public law issues. And connecting to your point on the virtual states. So that's why I think that there should be like kind of a model. I don't think there are going to be so many metaverses. I think they're going to converge at some point. But there should be a model there so that their internal regulations, they respect certain principles, constitutional principles, public law principles. Also dealing with what you mentioned about erga omnes and registration of property rights. You cannot do this with the Lex Mercatoria because that was a private thing, but now we have public law components. And so, yeah, I will maybe try to work more on that. I also agree with the comparative law. I do teach comparative law as well, so I'm familiar with the method. And finally, I have like kind of a question to you, because you mentioned the economy of experience and that there's not going to be scarcity in the metaverse, but we have issues of energy, and I'm not so convinced that it's going to be like unlimited resources. And I do think that besides experience, the metaverse is a huge market. And you know, with money, because cryptocurrencies bridge the gap between the real economy and the virtual economy. So it's not just for fun, this is also money. So, I don't know, but a good point anyway. Thank you very much.
Thank you, Anna. Jacopo, please.
Thank you very much for the very inspiring comments. I would just briefly addressing the comment concerning fragmentation. I totally agree that in this moment there is a risk that this kind of attempt by national government to introduce regulation that would in some way compete with the European one would just slow or impair the harmonization in a market that is totally global or common. So there is no reason for just proceedings one by one, I would say. My feeling is that there is a bit of a run or race in the sense that European Union is pressed to adopt quite quickly act by national government, and national government are pressed to do the same by private regulation and by self-regulation by, in this case, maybe advertising standard authority, etc., that are more quick to adopt soft law rules, etc. So my idea is that there is a bit of racing in adopting rules, and that may not be totally useful to the purpose. Yes, thank you very much.
Thank you, Jacopo. Marcos, please.
Thank you very much for the different insights by both of you discussants. I found them really inspiring and interesting. I have just like this I found this interesting idea in what Antonio has said, this ultra personalization of experiences, and also not only ultra personalization of experiences, but just customization of everything. That I think it's what we are going for, right? We have this a lot of very potent brands going right now into the metaverse, and I see two trends here. We're not going to just confirm themselves with digital twins, because the value of digital twins is going to go down really, really quick. So we're going to have like this more flamboyant kind of digital assets, because, you know, it's a social space and we like to show off in digital spaces as a species. That's not as a data. I'm not valuing it if it's good or bad, but it's what has happened, and it was what we have seen in MMORPGs and other kind of similar social virtual experiences. So that's one thing we're going to go. And then the next step is to personalize them. And to personalize them, if we are still in a proprietary copyright scheme, we need to solve the problems of licenses, because what do? We trace back to the author, to the creator who may have forgotten all, and we ask him if we can customize or we cannot customize the item because the user wants to change the color. Because that's what happens when we have copyright. We need that permission, right? So that's what I was thinking, that, okay, we need to take a simpler tool. I hope it was simpler here than in written, because I know I get carried away and it may sound like a little complex, a lot of complex structure for just a tiny niche problem. But I think what we need to is, the thing of the metaverse is to replicate reality, but we can simulate how reality works. And I think that's the key point. We can take the structures, the legal structures we have, and we can tweak them in order to make a simulation of how they may work. That's what I aimed here. So we have digital assets. Digital assets have their own law, or may have their own law. Okay, let's see how we can fix that in order to make digital assets work, emulate physical properties, emulate physical ownership without changing the legal environment. So that's what I mostly aim, but I couldn't delve very deep into during the 10 minutes chat. So if anyone is interested, we may exchange ideas.
The point,
Yeah.
the point is that you cannot customize the licenses. You have to choose among some fixed license because otherwise it doesn't work. I mean, from the real world.
Yeah.
You can negotiate a single license for a single use. So you may have a scheme of 10 potential licenses. And you use one of them.
I'll make sure to make it clear in that way, but what I aim is to have to fragment the licenses into very particular specific rights, like this customized yes, no, and with an opt-in scheme that makes standardizable licenses with different tweaks. Yeah, that's what I meant, and I think that's all for me.
The Creative Commons you refer to, right?
Yeah, the Creative Commons, but I want to make this remarkable. I'm not meaning that we need to relinquish IP. I think IP should be, at least for now on, it depends how it develops. I think what we need to do is to allow better, I don't know how to say, to better function both realities, ownership on one hand and IP on the other, because I think NFTs and this kind of technology may allow for that. That's just my impression. Thank you very much.
The main argument was that of scheme interface.
Yeah, because, okay, so I couldn't delve that in the exposition, but the main key here, I kind of align with, I think there is a problem if we centralize everything into these platforms, because we come from a Web 2.0 where platforms are dominant. If we don't end this trend, the platforms will take more and more space, with the problem that platforms, as the keynote presenter today said, platforms are focused on making money. So if we let platforms to grow array how they want, and they become regulators, which is pretty much the orchestrator concept I saw it in slides, if they become real regulators that can take for themselves copyright, privacy, AI regulations, content moderation, we have seen, I think there's an inherent danger in that, because there is no guarantee that we are going to have competitive virtual realms. These digital markets are a coin flip most of the time, so we have very few racing competitors, then the market flips, and we end up with just one. That happens with social media, with social platforms. We had a lot in the early 20s, then we have Meta, because it has WhatsApp, it has Instagram, it has Facebook. Then came TikTok, which is changing the schemes. But I think we cannot take things for granted from a competition law perspective, from an antitrust perspective, because it's not granted that we are going to have competing platforms. And it's not granted also that these platforms are going to have the same relevance and the same dimension as the bigger ones, which is something that has happened already. And then we have these problems of techno, feudalism, extermination zones. So we may need, and I'm sorry for taking too much time, we may need to reassess these kind of things. And I think that the main issue here is that copyright can be used as a tool for creating a platform-friendly environment, let's say so, right? That's the main fear. That's why I wanted this kind of system. Thank you very much for...
Thank you. Excellent conversation indeed. Germa, would you like to close, please, the round of...
Yes. Yeah, thank you for your comments and for the feedback that I found it totally appropriate. Actually, after listening my colleagues in the talks, it gave me a lot of ideas to complement my paper. And yeah, for sure, I think it would be better to make a comparison between Latin America regulations and Europe, especially because it's like a very strong connection for many reasons. Because when the consumer law statutes in Latin America were created, probably Latin American startups didn't have enough experience about the e-commerce. So that's why many of the rules were like the imitation of the Europe. But nowadays we have seen something a little bit different, because we're still watching, we still haven't seen like what the European Union is doing about artificial intelligence, about regulation in the e-commerce, digital assets. But nowadays, the Latin American countries has like a lot of startups that are even they are unicorns. They are working in technology and they are leading ideas worldwide. So now we are like also accommodating the rules to our reality that is more different than the reality that we have like 10 or 12 years ago when the first like consumer law acts were created in Latin America. That's why it's an excellent idea, like to explore not just because comparative law is not just putting rules like randomly, but just explain why those regulations exist and things happen, because also people behind the creation of the rules in Latin America has been studying here in Spain, in Italy, in France, in Germany, in United Kingdom, and also you can see the influence in the regulations, because they discuss those things with professors and academics here in Europe. So definitely I'm gonna make it an extra job now, but I'm gonna make it because I think it would be really, really interesting to finish my paper.